Hello everyone, this is Paritosh Mishra, an intern at ubAdvocate under the guidance of Jeevan Prakash, Advocate on Record, Supreme Court. The topic of my discussion is RTI, that is Right to Information Act 2005. The RTI is a law enacted by the Parliament of India to provide for setting out the practical regime of right to information for citizens. It applies to all states and union territories of India. Under the provision of the Act, any citizen may request information from a public authority, which is required to be replied expeditiously or within 30 days. The Act also requires every public authority to computerise their records for wide dissemination and to proactively publish certain categories of information so that the citizens need minimum recourse to request for information formally. This law was passed by Parliament on 15th June 2005 and came fully into force on 13th October 2005. Now we need to understand that what led to the inception of RTI. The right to information movement in India began with the Mazdoor Kisan Shakti Sangathan movement this was a movement to bring in transparency in village accounts through the demand for minimum wages in rural India. False entries in wage rolls were a sign of increasing corruption in the system, which encouraged the Mazdoor Kisan Shakti Sangathan to demand official information recorded in government files. Through this, the need of RTI was recognized. Now we need to understand the concept of RTI under the Indian Constitution. The Constitution of India does not clearly provide right to information. However, the Supreme Court held in several cases that right to information is concerned with the Article 19(1)(a) and Article 21 of the Indian Constitution. In other words, we can say that the RTI protects the very purpose of these articles. Article 19 and Article 20 comes under Part 3 of the Constitution, which is fundamental rights of the fundamental rights of Indian Constitution. In this way, we can say that RTI might be considered as fundamental right of the Constitution. Now, we need to talk about the aims and objects of RTI. Here, it is pertinent to mention that RTI was enacted to provide transparency and accountability of the sovereign authority to the people. Under this Act, an individual can make an application to get the information from the public authority. It aids to check the working system of the government. In the democracy of India, where its citizens play a very crucial role, it is necessary to provide them adequacy, transparency and accountability of the government. But there are few exceptions which needs to be taken into consideration. Because the question which arises is that is the individual has the right to get any information from public authority. Article 19(1) concerns with the right to information, but Article 19(2) of the Constitution also states that if the disclosed information affects the integrity or security of the country, then government can impose restriction on such subclause. In other words, a citizen can get the information to the extent which does not affect the secrecy and dignity of the country. So, RTI is not an absolute right. Section 8 of the RTI concerns with the exemption from disclosure of information which is not to be disclosed by the public authority. And now the main issue which pertains with RTI is the lack of awareness, for which I am arguing on this point right now. The right to information had provided an awesome right to the citizen of India, but still there is not sufficient awareness of the people among their rights. In order to achieve the objects of the Act, it is now our responsibility to share such information. Therefore, I urge NGOs, law students, lawyers and all others involved in the legal profession to do so in order to bring justice to society. And now, at last, I would like to thank ubAdvocate to provide me with such an opportunity, a platform to express myself and to contribute in this awareness program. Thank you so much.